Okay. So last night I recorded a lecture on civil law, and today this morning before class I'm going to record the one on criminal law, just so you have both of these in case we don't finish them in class. Okay. So the idea is that criminal law is different than civil law, and that it's not just between parties; it's between our society and you, right? The criminal law is an affront to society. Our legal system, our government, will step in and charge you, prosecute you on behalf of society, right? So civil law is mostly a matter of money or sometimes doing or not doing something, but mostly money, right? Criminal law is when the government is prosecuting, the government is paying for the witnesses, the government is paying for the jury, the government is paying for your jail, your prison sentence, the government is paying for your probation officer afterwards, right? So the government is taking on a lot of the burden here because they're doing this on behalf of our society, okay? Terminology wise, the person being charged or being sued is still the defendant, but instead of being called a plaintiff, the person suing is called the prosecutor. So the government is prosecuting you for a crime, right? It's not a plaintiff suing a defendant in civil court. It's a government prosecuting in criminal law, right? Okay. Um, slide. There we go. So there are a few kind of classic classifications of crimes. So there's two main historical types. One is mala in se crimes. So those ones are where there's something really badly intrinsically wrong about what you've done, right? Everyone can agree. So it's like rape, murder, arson, theft, right? These are things that, back to the dawn of time, humans have been like, that's a bad thing, right? There's also a bunch of crimes that are historically called mala prohibita. That is, they're wrong because our society just works better when you don't violate these rules, right? So, mala prohibita are things like jaywalking or uh, maybe speeding, right? There's not a huge moral stigma if someone jaywalked. We're like, yeah, you shouldn't have done that. We're going to give you a ticket, So carrying a weapon without a permit to carry a weapon, right? Or gambling illegally, or public intoxication, right? These are things that feel like there's like a we just don't like them, but it's not like you're a terrible person because of it, right? Okay. Um, in modern days, we usually classify things on three big buckets. So ignore the mala prohibita, mala per se. The buckets we usually have now are crimes against people. So that would be the rape, the kidnapping, murder. That's the classic mala per se, right? Or crimes against property, which is robbery, burglary, arson. Okay. And then there's also crimes against the government. So that would be like lying in court or bribing an official. So in those classifications, there are often two different levels of seriousness. Um, the levels of crime generally are defined by how long your punishment might be. So if it's less than a year in jail, will often be called a misdemeanor. And if it's more than a year in prison, up to death, then it's usually called a felony, right? So what possible consequence you could face is usually what defines the border between misdemeanor and felony. Okay. All right. So this is probably on your quiz, so make note of this. There are usually in every crime a certain number of elements. It's usually the main two elements are one, you did something bad, right? A wrongful act. And two, you had a guilty mind, you had intent, you had um, knowledge, right? Malice aforethought. Also, there's a bunch of different terms for the kinds of intent you might have, but basically, you have to do something and know you did it, right? Like if I walk out of the classroom and I grab someone's backpack, thinking it's my backpack, I'm not guilty of the crime of theft. I thought I was taking my own backpack, right? So you have to both do the wrong thing, take the backpack, and intentionally do the wrong thing. Okay. Um, the third one is causation. So it means basically that what you did has to have harmed, caused the actual harm. There has to be a connection between your act and the harm that was caused. There can't be some sort of interceding act. Um, and then sometimes there's a special circumstance. That's usually for like murder, where the 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 penalty is life without parole, right? So there's some really extenuating things where it's like, not only did you kill someone, but you killed a witness in a trial, right? To try to get your boss away with murder, or you murdered someone, but you also tortured them before you murdered them, or you murdered someone knowing they were a police officer, right? So there are extenuating extra things that can increase the level of your punishment, basically. So let me give you a hypothetical. Um, let's say Janine gets into a fight with her boyfriend Conrad after senior prom. Okay, so the prom's over. Janine and Conrad are in a fight. She grabs Conrad's car keys and she jumps into the car and she locks all the doors. And Conrad walks over really angrily and she starts the engine and puts the car into drive. And then she tries to run Conrad down. And it's dark and it's difficult to see. Um, and so Conrad jumps out of the way. He's unharmed. But Janine is thereafter arrested and charged with attempted murder. Um, so, what was the wrongful act? Just think about it for a second. What did she do wrong? Right. So, she drove towards Conrad in a way that could harm him, right? Could kill him. It's going to be up to the prosecution to prove that she did it knowingly. And there's a lower level of intent where it's kind of called just reckless endangerment, right? Where there's a high like probability that you will hurt someone with your actions, and as long as you're being reckless, that's enough intent to prove a lower level of attempted murder, right? Um, okay. There are some Latin terms you will hear sometimes for these two things, the wrongful act and a guilty mind. The terms are actus reus, you did the thing, or mens rea, right? You had the mental thought. Um, So act and mind, right? Actus and mens rea. Just remember those two terms. You'll often see them in our exams, but also just in life when you're talking to lawyers, they might say, "Well, what was the actus rea? What was the mens rea? Do they have mens rea? Do they have a mental um, plan to do this crime?" Right. All right, here's some examples of what these actus reus might be. So for larceny, the crime is unlawful taking and carrying away of another person's property with the intent to deprive them of that property. This is my backpack example, right? The actus reus is the taking and carrying away of that backpack. That's the wrongful act. It says nothing about whether I intended to do that, right? So that would have been the mens rea. The crime for assault is a harmful touching of another person with the intent to cause bodily harm, right? So the act is touching someone else, right? Harmfully touching someone else. So I could just be like, have my eyes closed. I'm just, dancing. I'm in a mosh pit, maybe. I don't know. Um, and I punch someone in the face. I didn't even know they were there. I had my eyes closed. It was not with intent, right? So I wouldn't be guilty of this if I didn't have the accompanying mens rea. The actus rea is me punching him in the face, right? All right, question for you. Just think about this for a second. Can an involuntary act be considered a crime? Knowing what you know about actus rea and mens rea. And the answer is generally no, right? Um, if we are sleepwalking and we punch someone in our sleep, I couldn't have had the mens rea, right? Even if I actively did it, I did the actus reus, right? I did the thing. Um, you have to have the mental culpability as well. All right. I'll say there's some weird exceptions. So if there's a voluntary act followed by a non-voluntary act, um, that can be criminal, right? So I'll give you an example. Um, let's say you go to a party and you consume a bunch of alcohol, and then you attempt to drive home. You're completely drunk. You can't see anything. Everything's blurry. You pass out while you're driving, and you crash into, a mother and child crossing the street and kill them both, right? You might say, well, clearly he couldn't have, done that because he was passed out at the time, right? So it's not his fault. He didn't have the mens rea. Um, the court will likely convict him of one or more crimes in this situation because the act of drinking all those glasses of wine, and then getting in the car, those were still voluntary. He still was conscious. He still was making choices. That was still an intentional thing, right? And as a society, we want to punish those kind of choices, those acts, that could eventually end up in the unconscious harm that he did later on. So does that make sense? So there's sometimes where you do an act when you don't have the intent, but we're punishing you for the intent earlier that led to that involuntary act. Okay. Um, some examples. Martin v. Alabama was a case where Martin was drunk, right? Officers came to his house and they took him to a gas station and then arrested him at the gas station for public drunkenness, right? Well, the court said, well, he wasn't guilty in public of being drunk in public because the act of him being in public, that wasn't voluntary. You took him in your police car into the public, right? So they found him not guilty because even though he had the mens rea to get drunk, he hadn't actually personally committed the act of being drunk in public, which was part of the statute of his crime. The officers had made him be in public, right? Another good example is People versus Decina. Um, this is where a guy had a seizure. He killed like four people while he was driving. He'd had seizures before, though. And so he was charged with operating this vehicle in a reckless or culpably negligent way, and causing these four deaths. And the question was what I was kind of talking about with the drunk example. Um, yes, he might not have had control then, but he had foreknowledge that he had had seizures while driving before. And so he knew there was a high chance he would have a seizure this time. And so the courts found him guilty in this case because they thought the very act of getting in the car and turning it on and starting to drive when you know that it's a reckless act to do that, that makes you guilty of having the requisite mens rea to be guilty of committing a crime, right? All right. So here's a question. Can planning a criminal act be a crime? If you let me give you a hypothetical. Um, let's say you are a housekeeper. You work in this house, and you've got this elderly client who lives upstairs, and you're thinking about stealing all of her jewelry. She gets out of she stays in her bed all the time. She never gets out. She has no idea she even has jewelry anymore. She's kind of like she's got dementia. She's got no kids really. What's the harm? I could steal all her jewelry, right? And so let's say you have a journal that you keep every day, and you're always jotting down which jewels you're going to steal from her house, how you're going to do it, right? How you're gonna hide your crimes. You're gonna rig the gas line so gas pumps into the house at night and kills Phoebe while she's sleeping. This is the old lady. Um, and let's say you even have a date. I'm gonna kill the old lady tomorrow, and you put that in your journal entry, right? And let's say you as you're leaving, you're tucking her into her bed, right? You lean over, and the journal slips out of your pocket and lands on her mattress, and you don't notice, right? And you leave. And the old lady's laying there. She picks up the journal and she opens it up and reads all about how you are going to steal all her jewels, how you're going to kill her in her sleep with a gas line leak. And so she calls the police and she gives them your diary and she insists that you be arrested for attempted murder, right? So after all that, is that attempted murder? Can you be charged with anything? No, you cannot, right? So we don't do thought police. You can have the most elaborate plans as long as you don't take any steps towards enacting those plans, they can't charge you with an attempted anything, right? So if you had, for instance, said, "Hey, I'm going to kill her with a gun," and you had gone out and bought a gun, or let's say we're doing the gas line thing, you had ordered, gas line cutting saws or something, and Amazon, had just delivered it to you. These are overt steps towards the furtherance of that crime. And so in that case, the police could charge you with attempted murder, right? But if you're just thinking about it, writing it down, you know, doodling a sketch of the bank or whatever, they're not going to charge you with those things, because we don't charge you for just having bad thoughts, right? Is there ever a case where you have a duty to act, and if you don't act, that's a crime, where it's the opposite, right? Often we say you've got to have an act to have there be a crime. Is there a case when just not acting is a crime, right? If someone's in danger and you don't step in and save them, right? Let's say you go to a store and you see someone else shoplifting. Um, do you have to say anything to anyone? No, you don't. It's not a crime to know about a crime, right? Um, just because you have inside information about this crime doesn't mean that you have to share it with anyone, right? Um, I put this case on this slide. It's called People versus Beardsley. It's a pretty old case, but it was a case in Michigan where the defendant uh, took his mistress to a hotel, and they got really drunk, and she took some morphine, and she died. And he was charged with manslaughter, and he was found not guilty, because even though he knew she was in medical distress, that she was, dying from an overdose, he didn't have a duty to act. He maybe had a moral duty, but he didn't have a legal duty to save her. Um, I think that case would actually come out differently now because there is sometimes a statutory duty in a few situations. And one of those situations is if you have exclusive control over the situation, right? No one else, is going to come into your hotel room and that person could die if you don't do something. In that case, courts have read in kind of a special relationship between you and the person that you're kind of caretaking over. Usually the caretaking relationship comes in with parents and kids. Like, just because your kid is starving because they haven't eaten in weeks because you haven't fed them, and you can say, well, I didn't actively poison them, I just didn't feed them. I don't have a duty to act, officer. And we think, you know what, you do have a duty when you've got that special relationship between a parent and child. Or even like, you've got an elderly person you're taking care of, right? No one else is going to help them, so you have a duty to help them. Um, and then there are some specific statutory duties, like if you're a teacher, for instance. I am a mandatory reporter as a teacher. So if I know a crime is happening or someone's in danger, I've got to report it, right? Um, and so very often teachers in, K through 12 and college have a duty to report crimes that are happening, right? So that's the one place where I would have to report something, and that failure to act could itself be a crime. Crime. So to sum up, you've got a statutory duty to act. So things like that would be filing taxes, a contractual duty to act, like you are the daycare provider, right? So I'm paying you to act, right? Or as a result of that special relationship you might have, such as a parent-child. Okay. So let's talk about mens rea a little bit. Mens rea, this is also often called the guilty mind, right? This is just the intent element. So my example was that I've got to know the bag is not mine to have that intent to steal your bag. Um, Crimes that are classically mala in se, that is the real bad crimes, murder, rape, arson, etc., those always require proof of intent. Um, the mala prohibita crimes, and this is again where kind of interpretation of law comes in, where the courts can figure out what laws mean. If it's a very low level crime, um, like a traffic violation, or another example is sale of alcohol to a minor. The courts basically say, prosecutor, you don't have to prove intent on this, right? The fact that they sold the beer to someone who was 10 years old, they didn't check the ID, we're going to assume intent, right? So the act itself sometimes is enough for a crime when it's a low level crime, right? You were going, and we clock you on the radar, going, 90 miles an hour in a school zone. Um, I don't have to show, you don't have to prove intent that you intended to go 90 miles an hour. We're going to assume that because this crime is so low level, right? It's just a mala prohibita crime. So that often happens. You often will see even the language of the law doesn't talk about intentionally sped, right? It just says that you sped. That's the thing that's prohibited. Right? All right. So remember, it's actus reus plus mens rea plus sometimes in special circumstances and causation equals a crime. Um, so larceny. Here's the definition of larceny again. So it's the unlawful taking and carrying away of another person's property with the intent to deprive them of that property. So the mens rea is the intent to deprive them of that property. So this is one of those mala in se, I've got to prove that intent, right? I can't just prove that you took it and carried it away. I've also got to prove that you knew it wasn't yours, right? Or that you didn't intend to give it back to them. And then, as I said, sometimes the law it's read into the law, mostly for those mala prohibita crimes. All right, so let me give you a question. What result? What's the result if I intend to shoot and kill my girlfriend, but she ducks and I kill her mom, who's standing right behind her? Well, courts have interpreted this to say, well, you intended someone to die, right? Even if you didn't intend the mom to die, you still had the intent to kill. And so we're going to transfer that intent to the actual harm that was caused. So you might argue, I didn't intend to kill her, I intended to kill her, right? The courts don't care. You did the act of pulling the trigger on the gun with the intent to kill. Just because someone else was killed, we're not going to let you off, right? So especially if it's a serious crime, we will actually transfer that intent to the actual victim. Um, Question: do you think you can be charged with both the murder of the mom and the attempted murder of the girlfriend? Generally, no. So let's say the mom's not in the picture. Let's say I raise the gun at my girlfriend, I shoot, and she dies, right? I'm not going to be charged with both attempted murder and murder. The attempt merges into the actual crime. So once the crime is completed, the murder is completed, I'm charged with murder, not attempt. Um, so if I'm transferring the intent to the mom who's actually killed, the mom is back in the picture now. Um, the attempt on the girlfriend will merge with that new crime. So even though it's against two different people, they can't charge you with both things. That makes sense. Okay. Um, what if I try to shoot my girlfriend, but she ducks and the mom ducks too? And the bullet goes out the opposite window, kills a duck in a pond. Um, is there a crime? Let's assume it's hunting season, and I'm not in trouble for I have a hunting license, so I'm not in trouble for killing the duck. Um, yes, so the crime would be attempt. So if you are trying to commit a crime, even though you fail, both with the girlfriend and the mom, you can still be charged with that attempt, just not the actual completion of it, right? So you had the act, you had the intent. Just because there's no harm doesn't mean there's not a crime. Remember, harm wasn't an element of there being a crime or not, for most crimes. Actual cause, or which is often called the but-for test. So my example of this is Oxendine versus State. This came out of Delaware. And basically what happened is the defendant and her boyfriend, they had a kid. It was the defendant's kid, right? Actually, defendant and his girlfriend had a kid. And the the um the girlfriend had pushed the kid down the night before, and it had caused a bunch of like tears internally in this kid's stomach from when he hit the ground. Um, the next morning, the defendant, the boyfriend, punched the kid in the stomach, and the kid ended up dying from having this internal bleeding all throughout the night, and then the punch. Well, the jury found that the punch definitely had aggravated the injury, but it hadn't accelerated it. The kid was still going to die, whether or not there was a punch that hurt his stomach. So without the defendant's punch, the kid still would have died, is what they found. So they found the defendant not guilty of murder of this kid. Um, so that's an example where there was a crime. The guy intended to hit the kid in the stomach, right? And did hit the kid in the stomach. So there's an act and an intent, but the harm that was caused, the death, had actually been set in motion prior to that punch. Um, so that's the but for test. So, but for your action, would it still have happened, right? The other one was the proximate cause. And my example in this is People versus Rideout. It's a Michigan case. So in this case, the defendant was drunk. He crashed into someone else's car, and everyone was fine, right? But after checking on the defendant, the person who'd been crashed into, the victim, went back to their car to turn on the flashers to make sure no one hit them. And that's when a car came and hit him, right? So the question was, you know, sure, but for the accident, that person, the victim's name was Kelsier, or Kaiser, I think. Kaiser, um, Kaiser wouldn't have been stopped and walking in the road, right? So if we use the but for test, that would have been he would have been found guilty. But the jury used what's called the proximate cause test, right? To figure out it, what was there an intervening action, right? Someone else who was driving poorly who caused this accident, someone who didn't see an accident on the road and slow down, right? Um, let's so the jury found him not guilty based on the proximate cause test, because it wasn't his fault that one, the guy walked back to his car in the dark, two, that another driver hit him in the dark, right? Let's pretend, though, that in that accident, Kaiser was actually very badly injured in the crash, right? And he was taken to the hospital, and the doctors couldn't save him, right? Could you say, well, it was the intervening work of the bad doctors? And the answer is no. So the proximate cause is basically looking for whether the harm is reasonably foreseeable, right? And going to the hospital is a foreseeable result of of a crash, right? And people dying in hospitals is a foreseeable result of a crash, right? So all those things were foreseeable. It was just not foreseeable. The jury thought that he would walk back in the dark and then get hit by a random car, right? Okay, that's causation. I thought we were going on to inchoate. So inchoate crimes is when someone has taken steps to commit the crime, um, but it hasn't been completed for some reason, right? So we've already mentioned one inchoate crime, and that is attempt. So there's three ones that I want to go over, right? So one is solicitation. So this is an offer to commit a crime. Like, I hire you to commit a crime. You go kill my wife. She's upstairs. Here's some money, right? Um, if we are both trying to kill my wife together, that might be a conspiracy, and then I wouldn't be charged with solicitation. I'd be charged with conspiracy. So that's why it merges with conspiracy. If we're both charged for the crime, it becomes, we're part of the mafia or something. Trying to kill someone, that's not a solicitation, that's a conspiracy. But if it's me saying, you go commit the crime, I would be charged with solicitation. You'd be charged with attempted murder or murder if you do it. Conspiracy is where we all agree to commit a crime, right? This doesn't merge. So if we agree to kill someone or to, form the mafia in in our fair city of Seattle, um, then that itself is a crime. Joining a group of people that want to commit a crime, and the crimes itself that we commit, those are also crimes. So conspiracy doesn't merge. So just joining a conspiracy by itself is a crime. The crimes we commit are also crimes. Solicitation, that merges with the crime. So once I've solicited you, um, that's a crime. But if I join the conspiracy, a part of it, I can't be charged with solicitation anymore. Okay. Pinkerton liability is an interesting one. That's the idea that once you join a conspiracy, that some jurisdictions say that you are now on the hook for all further crimes of that conspiracy. So let's say I join a conspiracy with a bunch of guys. We're in a gang now. We're gonna go rob a bank. I go home and say, "Good job! I robbed a bank today. That was great." Um, they are not done with the night. They're like, "Hey, we're still young and fresh. Let's go, rob someone at an ATM too." And they go to an ATM and rob an old lady, and she falls down and kills her and hits her head and dies, right? Am I still on the hook for that ATM robbery and her death, even though I was fast asleep? And some jurisdictions say yes, that follow the Pinkerton line of cases. They say you joined a conspiracy to get money, and anything this conspiracy does now to get money, you're on the hook for. You're part of this gang now. You're part of this conspiracy. Um, the actual Pinkerton case was a tax fraud case, and one of the brothers in this case was actually in jail at the time, but the court still found him guilty of the tax fraud because he was part of this conspiracy. And how you get out of a conspiracy can be really difficult. So a lot of jurisdictions, make you affirmatively drop the conspiracy and not even just going to the police, but telling everyone else, "Hey guys, I no longer want to be part of this conspiracy." So you have some jurisdictions make it a really high bar to get out of a conspiracy. So just FYI, if you're in a Pinkerton liability place, I'm not sure if Seattle is or not. I don't think it is, but a lot of jurisdictions are. And then attempt, I kind of already talked about, and that's just where you try to commit a crime, but there has to be some kind of overt act. It can't just be the thought crime thing, right? You've got to do something to make it an attempt. But then if that crime gets completed, attempt merges and disappears once the crime has actually been completed. Okay, so you've been accused of a crime. What if you think, well, I might have done it, but there are reasons why I did it that should outweigh, my guilt, right? These are your defenses, right? So maybe I'm insane, or maybe it was self-defense, right? There's a bunch of different reasons why you might commit crimes that would actually say to the jury or to the judge that you don't deserve punishment for this crime, right? These are your defenses. So one defense that's very popular is mistake of fact, right? So this is People versus Navarro is my example. So in this case, the Navarro ended up winning, right? So what the case was, the defendant took these like wooden beams from a construction site because he thought the site was abandoned. He thought the material was just thrown away, rubbish. Um, but he was charged with grand theft and he was convicted of petty theft. Um, so the issue was whether he stole this or not, right? So the crime in the case was every person who shall feloniously steal the personal property of another is guilty of theft. And he says, well, I didn't steal it. I picked up abandoned wood. That's what I thought. So his intent was to pick it up um, and take it, but he didn't know he was stealing it. So the knowledge wasn't that he knew he was picking it up. The knowledge was he was doing the stealing, right? So he was not charged with the grand theft that he was not convicted of the grand theft, but he was convicted of petty theft. Um, South Carolina versus Blurton. That was a defendant robbing Walmart for the CIA. Oh, this guy was an idiot, right? So it was this guy who he was convinced by a friend, this guy named Mayfield, convinced the defendant Blurton that Mayfield was actually a CIA agent. And he says, hey, the CIA is trying to pull this sting on Walmart, and I need some people on the inside to kind of like test out Walmart's defenses. And so what I want you to do is I want you to go in and steal from Walmart, and we're going to use this as in evidence against Walmart somehow. Um, and of course, he got caught, and he's like, "No, the CIA told me to do it." And Mayfield was not a CIA operative; he was just messing with this guy. So the statute in that case was robbery is the forcible taking of personal property of another with intent to permanently deprive such a person of the property. Um, and it didn't go well for you'd think it wouldn't go well for Blurton, but he actually won. The jury believed that he legitimately did not know that the guy wasn't CIA. It does have to be a reasonable mistake of fact, though. They thought it was reasonable, but the idea is that the mistake has to take away your mens rea in some way, right? Some jurisdictions will write laws that say that mistake of fact can't be used as a defense in certain circumstances. For instance, statutory rape laws, right? Where you're like, I thought she was, 18, because they don't want you to be able to use that to get away with crimes, right? So mistake of fact is frowned upon in certain circumstances. Also, I should say the opposite isn't true. This is my example in People versus Thousand. Impossibility isn't a defense. So mistake of ability to do it. So this was a Dateline rapist case where he thought he was going to have sex with a 14-year-old, right? He shows up and she's actually an adult just pretending to be a 14-year-old. And that he said, well, yeah, I had the intent to have sex with a 14-year-old, and I went there, I did the overt act. But even if I had gone through with it, I wouldn't have committed a crime because she was an adult, right? She was undercover or something. And the courts have said, just because you didn't know this fact that the actual crime would be impossible doesn't mean you didn't have the intent. So they just because you can get off if your mistake causes you to not have the mens rea, right? If your mistake causes the crime to not be able to be committed for real, the courts won't let that happen, won't let you get away with that. So he still got charged with attempted rape of a 14-year-old, even though there was no 14-year-old. That make sense? Okay. Mistake of law is not a defense. Just because you didn't know it was a crime doesn't mean that we're going to let you off, right? You often, hear like in TV shows this phrase, ignorance of the law is not a defense, right? My example here was People versus Marrero. New York case, federal corrections officer entered a club with a gun. New York law says state police officers are exempt, but not federal officers. And he's like, well, I didn't read the word federal. I thought I was exempt. It's, I didn't realize that was against the law. My bad, let me off. And he was found guilty. It was a reasonable mistake, right, to make. He missed one word in that law, but we generally in our system don't allow mistakes of the law to be a defense because then everyone's just going to say, I didn't know it was a legal officer. The end, right? Okay. There's two big classifications of defenses I want to go through next, right? So one is the justification defenses. Okay, justification defenses. So this is where the defendant admits to committing the crime, but they say under the circumstances, you, society, wanted me to commit this crime, right? This was a crime that you wanted. The two examples I have are self-defense / defense of others and necessity. So the first one you probably heard about a lot in TV shows, right? Often they say, oh, it's self-defense. This comes up a lot. It's where someone attacks you, right? It's got to be an immediate or unlawful threat of bodily harm, right? They are coming at you with a knife, right? And you take out your knife or you take out your gun and you shoot, right? So you are protecting your own life or the life of your wife or something, or an old lady on the street, whatever. So you're protecting life, and taking life, or taking harm, stopping harm by giving harm. It doesn't have to be life. Um, Immediate is important. It can't be if someone comes up and says, "Hey, I'm gonna poison you tomorrow," right? You can't then take your gun out and shoot them, right? Because before tomorrow, you could escape. You could go to the police. You could not take a drink from them, right? So there's lots of things that could happen before tomorrow that are better than shooting someone in the face, right? Um, there are a line of cases where people set up booby traps in their houses to deter theft. Like they have, cattle in the barn and they set up a shotgun on a spring. So when the door opens, the shotgun kills someone, and protects the cattle. And every one of those self-defense attempts has been denied. We basically think that you are never justified, of killing someone because of your cow or your TV, right? So human life is worth more than property. Um, there, there are situations where people are allowed to come into your house, right? Let's say the Los Angeles fires, right? The firemen want to come in and make sure everyone's out. They can break the door down and come in to make sure there's no kids in the house, right? Um, we don't want a shotgun shooting our firemen, or our police officers who are trying to, follow through with a warrant, or an ER person who comes in because there was a report that there's a dying person in your house having a heart attack. We don't want the ER person, the paramedic, to come in and get shot by one of your spring-loaded shotguns, right? Or let's say there's a fire outside, or a tornado is probably a better example, and people are trying to seek shelter in your barn, right? Um, we want them to seek shelter. Yes, they broke into your barn. We don't want them shot to protect the sanctity of your cows, right? So your life has to be in immediate danger, right? Or your bodily integrity has to be in immediate danger. Also, the attack on you or others has to be proportionate to the response you give. So if they are saying pillow fight and hit you with a pillow, you can't then pull out your gun and shoot them, right? Um, you have to attack with a pillow as well, or something similar. Maybe a little bit more aggressive. You can punch them or whatever, to get them off of you, but you can't kill them because of a pillow fight, right? So it has to be a reasonable escalation, and this is up to a judge or jury to decide what is reasonable. Um, so reasonable force has to be used. Um, you also can't claim self-defense if you're the one who started the fight, right? So let's say it's a bar and they say something about your, girlfriend, and you punch them, right? And then they punch back at you and then you shoot them, right? You can't say, well, he punched me, because you started the fight. You punched him, right? Um, so you can't be the initial aggressor. And then you also can't be a person who could have easily de-escalated it, right? If you had a chance to stop the fight, to retreat, to back away, and you don't, or if you leave to go get a gun and come back, right? You can't be that person who retreats and then returns and says it was self-defense. You were already safe. You were gone. There's cases where people like go home to get a weapon and come back to shoot the person and then try to use self-defense. You can't do that, right? Self-defense has to be where you weren't able to do anything else, right? But defend yourself. There was a case a few years ago in Missouri called State v. Dill, and it was a guy in his car. Let's call him X because he died. Um, X was in his car trying to start it. It wasn't starting. It didn't have gas. Someone walked by, a guy named Dill, and he leaned out the window and was like, "Hey, man, you got a few bucks for gas?" And they kind of had an argument about, panhandling and whatever else on the street. And X got mad and still buckled in his seatbelt, still in his car, pulled a knife out and swiped at Dill, who was standing on the sidewalk. And Dill took out a gun and shot X and killed him. And Dill was like, "Hey, self-defense, man. The guy was trying to attack me with a knife," right? He thought that the jury would buy that, and they did not buy that. They're like, "You were on the sidewalk. You could have just kept walking. he was seatbelted in his car that didn't have any gas, right? He wasn't going to follow you. And if he did, then maybe you could shoot him then. But at the time, that's not a self-defense claim. You could have just walked away, right? Um, so one thing to note is that it's never reasonable to use deadly force to protect property. So if there's no threat to life, you can't kill someone, right? It's only if life is at risk that you could then use, it's then considered reasonable to kill someone, okay? The other one is necessity. And this is, again, there's not a reasonable alternative. So yes, I committed a crime, but there wasn't really another choice, right? Um, so the classic examples are, hey, there's an avalanche coming down the mountain, so I'm gonna break into your house to save my life, right? Break into your cabin. Or I'm on a boat and there's a storm happening. I'm going to dock on your private dock, and the waves are going to damage your dock with my boat smashing into it, but it's to save my life, right? I didn't have another choice. We as a society would rather have me alive than have your boat or your dock need, some repairs, right? Um, the Perdomo case is an example from a few years ago. It was Perdomo was a Mexican citizen. He had diabetes, and he couldn't get insulin um, in wherever he lived in Mexico. So he crossed the border into the U.S. to purchase insulin. And the border guards detained him, and they charged him with, coming into the U.S. illegally. Um, and he said, "Oh, defensive necessity. I had to live, and the only way I could live was to come in here to get insulin. And so I shouldn't be guilty of this crime because there was a necessity that was um, not as bad as the harm that would have happened otherwise. I would have died, or I would have crossed the border to buy insulin and then went back home, right?" Um, and the courts denied this use of the defense because they figured, you know what, there's mail. You could have ordered insulin. Um, you could have gone somewhere else in Mexico. There are lots of places in Mexico that sell insulin, maybe more expensive, maybe farther, whatever the issue is. That doesn't justify you crossing into the US to get your insulin, right? Um, so just like kind of the crimes where they have elements, like you've got to do, have the actus reus and the mens rea. For defenses, there are also sometimes elements. For this one, there has to be no reasonable and legal alternative for you to uh, not have done this crime, right? Um, you also can't trade equal or greater harms. So you can't kill someone else so you'll live. The necessity is got to be a lesser crime that we as a society would rather have than you dying or whatever it is. So you can't be like, the choice was me or this little girl, so I shot the little girl, right? That's not going to be necessity. Her life is just as valuable as your life, so you can't trade um, greater harms for your own, equal or greater. The other category of defenses are called excuse defenses. So justification, those are where you're like, under the circumstances, society would rather me have done this crime. An excuse is where society didn't want me to do this crime, but even though I did it, I shouldn't have responsibility for it, right? Because maybe it wasn't voluntary because of some situation, right? This is where um, uh, involuntary intoxication, which doesn't come up very often. It's where someone else drugs you and makes you and you commit a crime. So you didn't make the choice to take the drugs, but someone else drugged you. That doesn't come up too often. Um, but basically you don't have the mental awareness to be able to form mens rea. The one that does come up more often is intoxication, um, or sorry, insanity. God. Insanity. Um, Basically you say that I didn't have the ability to understand right from wrong, right? Um, and then finally, duress. So duress is where someone says, "I've got your family kidnapped. If you don't go in and rob that bank, I will kill your family." And you can go in and rob the bank and then claim I was under duress. The one thing the duress doesn't work for is murder, right? So you can't. they can't say, if I'm going to kill your family unless you go kill that guy, right? Because again, we don't like trading lives in that way. You should let your family die, basically, um, because their life is no more valuable than the life of some random person that you would have killed. Um, there was a case called U.S. versus Scott. And if you guys have seen Breaking Bad, the TV show, it's basically that plot. So Scott was, uh, he says this guy named Morrow had threatened to kill Scott's family if he didn't help him go out and get supplies for meth. So Scott was like going out to various different like pharmaceutical companies and warehouses, stealing supplies for meth to bring back to this guy named Morrow. And he said, I was under duress. Morrow was going to kill my family if I didn't do this. And the court said the point of duress is that you don't have the ability to regain control, right? Because they have your family. But because you were going out away from this person to go to, various companies and whatever, you could have easily in one of those companies made a phone call to the police and told them what was happening, or wrote a letter to one of the suppliers as you were in their warehouse stealing from them. So the court said, yes, you were under duress, but you had multiple chances to get out of duress by seeking help, and you didn't, right? So they wouldn't let him use the duress defense in U.S. v. Scott. Okay, so last couple slides, protections for defendants in criminal law. So protections are going to be higher. Remember, in criminal law, the burden of proof is much higher, right? So the burden of proof is beyond a reasonable doubt. In civil cases, where we're just trying to figure out whether they're culpable or not culpable, whether they pay money or not, it's a very low burden, right? So it's just a preponderance of the evidence, just slightly more than not true that they did this bad act. Once the plaintiff has proven the elements of whatever, thing they're charging, the burden then shifts to the defendant to rebut, right? So again, it's a low standard. The criminal stuff that we're talking about now, you're either guilty or not guilty, and the burden is always on the government. It doesn't shift to the defendant usually. It's beyond a reasonable doubt, and it's a very high standard. So it's 99% sure, 98% sure, right? The only cases where it flips the defense is if they are trying to prove one of those defenses I just talked about, right? They're trying to prove insanity, right? So then they had the burden to prove that they were insane. The prosecution doesn't have to defend, it doesn't have to prove you were not insane, right? Prosecution proves the crime. If you want to prove your defense, you can. But generally, the burden is on the prosecution for criminal cases. Okay. There are also a lot more, because this is much more dire in criminal cases. The consequences could be up to your life or to your life in prison. There's a lot more protections for you in criminal cases, right? So we'll talk about this when we get to evidence law, but there's the Fourth Amendment that says no unreasonable searches or seizures without a warrant, right? So we need probable cause as an officer and a warrant signed by a judge to be able to look at your documents in your desk drawer. It's lower for civil cases. In civil cases, remember, there's that process of discovery. We just say, give me the documents from your desk drawer. If it's relevant, they have to give it to you, right? So there's a lot less protections in civil cases about facts being exchanged. In criminal cases, they need to have a really good reason, probable cause, why they should be able to look into your desk drawer, right? There's also a Fifth Amendment right against self-incrimination, right? So in a criminal case, a defendant can refuse to speak or testify to the jury, and the jury is not allowed to use that as evidence of guilt. That's just one of our rights, that we don't have to testify against ourselves, right? However, in a civil case, the defendant has to be open to testimony and depositions, right? And if they don't, the judge can actually tell the jury in a civil case that they can take that, take an adverse inference on that. That basically, if they don't want to say they didn't do it, then you, the jury, can assume they did, right? That's only in civil. In criminal case, if they have an absolute right not to testify. Um, Criminal cases, there's a Sixth Amendment right to a speedy trial. And as you know, for a civil case, it can take years for a civil trial to be heard, right? I think I already told you, but my wife has been working on a case for like 6 years now. These things can go on for a long time, but not in criminal. Criminal, much, much faster. Weeks, months, maybe, sometimes a year or so, but like usually that's only because the defendant keeps appealing and keeps the case going longer. Um, there are kind of statutory rules about how long a case can sit and not be heard before a judge or a jury. And then in Sixth Amendment, again, you have a right to to counsel under criminal cases. In civil, if you can't pay for a trial, you don't get a trial, right? Except in that weird case I mentioned about contingencies, where the lawyer will cover all the costs and not charge you until they win. But generally, if you don't pay a lawyer in civil cases, you don't pay the filing fees in civil cases, you do not have a trial, right? But in criminal, you're guaranteed to have your counsel paid for you by the state, right? And there's one more big protection that you should be aware of for criminal cases, and that's this idea of jeopardy. Um, Jeopardy just means danger, right? So you can't be put in danger more than once for the same situation, right? So in a civil trial, the losing side or the winning side can appeal the outcome. They can be like, I didn't get enough money, appeal. I shouldn't have had to give you anything, appeal, right? In a criminal trial, if the prosecution, the state loses, they can no longer charge you with anything, right? They've lost, they had their one shot, they're done. Only the defendant can appeal the result, right? So the government cannot appeal a not guilty verdict. The prosecution also can't try lesser included crimes that are if there's a not guilty on the greater crime, they can't charge a lesser one. Actually, I was watching a TV show last night called Boston Legal. It was like just a clip on TikTok before TikTok is canceled, but it was a very short clip, and it basically was a court case where a guy was being accused of stealing a phone, and the prosecution proved or tried to prove that he had he had the phone that was stolen in his person, but they didn't prove intent. They didn't prove the mens rea. And so the prosecution rested. The defense said, we rest as well, not giving any evidence. And in closing arguments, the defense said, hey, you didn't prove that he knew that it was stolen. So you didn't prove an element of the crime, the mens rea. And the prosecutor said, well, we'll also charge possession of stolen property then. And the defense says, nice try, but you didn't charge the lesser included already, so you can't. Once the larger one is closed, you can't then come back and charge a smaller crime in the same fact pattern, right? Only if you initially charge that can you go to that. So that's the lesser included. I think that's all I have for this. Cool. Yeah. All right. I might get to this in class. I might not, but now you have a recording of this for you to look at your leisure.